Hi everybody, my name's Griffin Bridgers. This is part 2 of the basics of the portability election. Today we're going to dive a little bit more into general eligibility requirements that have to be met in order to qualify for the portability election. Now before we get started, I want to remind you this presentation is not intended to substitute for legal or tax advice and is provided for educational purposes only. So this is part 2 of a longer series on the basics of the portability election. I don't know how many installments we'll have in this series, but in part 1 we looked at some of the background that changed the planning assumptions that used to exist pre-portability compared to what we now have in terms of the estate and gift tax landscape. So in this part 2, we're going to dive more into the actual requirements for the portability election and when and how those come into play, and possibly even look at some blind spots that could come into play with those as well. Now, there are some requirements I'm going to table into a later talk because of the specialized nature of the inquiry, but what we're really going to look at today are some of the broader types of eligibility boxes that you must check. So, to begin with, to preserve a deceased spouse's unused exclusion, you obviously have to have a surviving spouse. Now, before we dive into surviving spouse, I want to remind you, portability hasn't always been around. It relates back to a change in law at the end of 2010. So, in order to preserve a deceased spouse's unused exclusion, they must die after December 31 of 2010. Now, as we're going to see, we may be well beyond your ability to make a portability election for people who died shortly after that, but you may be able to go back and get some late election relief depending on the circumstances. Now, a spouse is required, but this is where we run into an odd intersection between state law and federal law. Typically, a spouse is determined under state law for whichever state the married couple is domiciled in at death, or possibly even the state in which they got married as well. Now, this could include a union that's respected for federal tax law purposes under the Windsor and Obergefell cases, but it wouldn't necessarily include a civil union that's created solely for state law purposes, but which is not respected for federal tax law purposes. Now, I note that some states have common law marriage, and it's possible that you could also make the argument and get a court to issue an order directing that there was a common law marriage in a state, in which case potentially you could also claim a portability election in that scenario, even though there was never a solemnized marriage. However, I want to remind you that just having a surviving spouse is not enough. You have to dig into the estate plan and the assets and show that there is remaining exclusion under the estate plan and an election to preserve it. Now, I want to note that the availability of unused exclusion may depend on the estate plan itself and other tax elections that may be made, such as the QTIP election. We'll look at that on the next slide. And then, as we're later going to see, the deceased spouse should also be a U.S. citizen or resident, and there may be some limitations on a non-citizen spouse's ability to use the unused exclusion as well. So against this general backdrop, we're going to take, just for example, a quick out-of-the-sky example where we have $20 million left solely to a marital trust under an estate plan that qualifies for the QTIP election. So in this case, we have two potential elections in play. One is the QTIP election, and the other is the portability election, or the DeSuey. And what we're going to find out is that the two move in lockstep. So for every dollar over the exclusion, the basic exclusion amount, which is $12,920,000, for which you make the QTIP election, you'll preserve some unused exclusion. And, on the other hand, non-elected QTIP assets are going to use the exclusion of the first spouse to die, and each dollar of those assets for which the QTIP election is not made is going to end up resulting in a dollar less of exclusion preserved for the surviving spouse. So, in terms of that election and the broader strategy, we have to look at who actually makes this election, who makes the decision to elect portability, and even balance it with the QTIP election, as we're going to look at in a later part as well. So the authority is vested in the executor of the deceased spouse's estate, also sometimes known as the personal representative. Now, ironically, that executor could be the surviving spouse themselves to make the portability and QTIP election. However, it may be the case, especially if the right plan is put in place to avoid probate, that there may be no executor formally appointed. In that case, what the regulations say is that the person in actual or constructive possession of the property may make the election on the return, as we're going to look at in a few minutes. So, I want to mention that the authority is discretionary by default, but could be mandatory or possibly overridden from a discretionary perspective under the estate plan documents or even under other documents. So, for example, you could have a will or trust that requires a portability election, and you could even look beyond the will or trust to things like a marital agreement, where there could be a term that says upon the death of one or the other spouse that the unused exclusion has to be preserved for the survivor. So it helps to look not just at the estate plan, but also to any potential marital agreements or other types of property agreements that are floating out there. Now, one big question is whether the executor could be liable for a failure to make the election, especially if it results in unnecessary estate tax later on. Now, this is largely unsettled, but this is a risk, and you also have to consider this from the perspective of, let's say, a trustee of a revocable trust who might be delegated directly or indirectly the tax election authority as well. So it helps to kind of know the broad picture and note that the executor should not make the decision to make the election or not make it lightly. So when we get into the mechanics, we're later going to look at the specific parts of the form that we fill out and walk through an example of those, but for the time being, what you have to make the portability election is a timely filed estate tax return on IRS Form 706. Now, the definition of timely filed is really going to hinge on whether or not you're actually required to file an estate tax return to begin with. And that is going to depend on the composition and value of your estate and possibly your adjusted taxable gifts as well. So the basic requirements under the tax code are that if your gross estate plus your adjusted taxable gifts, if the sum of those exceeds your basic exclusion amount at the time of death, then you'll have a return that's due 9 months after date of death, with potentially a 6-month extension out to 15 months after date of death. So if you meet this requirement, you have to file the return. It's not optional, and your definition of timely filed is going to fall within that 9-month or 15-month window. If you're late, potentially you don't get the portability election. However, if you're under that threshold, the Form 706 filing might be optional for purposes of making a portability election or QTIP election or GST elections or whatever the case might be for situations where you'd have an elective Form 706. We're not really going to dive into all of those in this series, but I want to remind you that if you are filing solely for portability purposes and if there's no required return, in other words, if your gross estate plus adjusted taxable gifts don't exceed the basic exclusion amount, then you end up in this realm where Rev Proc 2022-32 now gives the estate of the deceased spouse up to 5 years to file a 706 to claim portability. So if you're beyond the original 9 or 15 month deadline, there are some additional requirements under Rev Proc 2022-32 that have to be filed, particularly a heading that you have to add to the top of Form 706. So ultimately, our definition of timely filed is going to depend on whether you have a required return or an elective return. So regardless of whether you have a required return or an elective return, what you're going to have to do to make this election is complete or not complete Part 6 of Form 706. So if you complete Part 6, your portability election is made. If you don't complete Part 6, you're deemed to have not made the portability election. And your decision to not make or make the portability election based on the 706 filing is irrevocable once the original deadline for the return passes. So especially if you have a required return. Once you file, you still have you have a chance to change the election as long as you file within the 9-month or 15-month window, but you can't change the election after those dates. It becomes irrevocable. You can't amend the return after that point. However, with an elective return, it's not clear, but it's possible and likely that if you file within the 9 months or 15 months, you don't necessarily get now a 5-year period to go back and change that election if you have an elective return. So if you're going to make the election or not make it, once you have your first filing, it gets hard to amend it, even for an elective return after that 9-month or 15-month window has passed. And I want to remind you, the 15-month window is dependent on whether you actually timely file an extension for the 706 as well. Now, one point I didn't leave out here that's going to really relate to our mechanics is going back to our definition of a required return. I want to again note that this is based on the gross estate plus adjusted taxable gifts exceeding the basic exclusion amount. So keep in mind the basic exclusion amount is just that $12,920,000 indexed for inflation. So if we had a prior spouse who made a portability election which increased our applicable exclusion amount to a point where that exclusion was greater than the gross estate plus adjusted taxable gifts, that doesn't mean we could avoid filing a return in that scenario. You still have to use the basic exclusion amount as your threshold determination for seeing if your gross estate and adjusted taxable gifts cross that threshold into required filing territory. Now, in terms of how much we get to preserve, if we make the portability election, we have to look at the positive difference, if any, between, one, I'm going to asterisk this, the applicable exclusion amount of the deceased spouse minus the taxable estate of the deceased spouse, and minus, if there are any, adjusted taxable gifts of the deceased spouse. Now, this is something I've asterisked because the technical definition under the code says that you can preserve the difference between the applicable exclusion amount and that tax base, the taxable estate plus adjusted taxable gifts. But I want to note that the term applicable exclusion amount includes any disuey of a prior spouse. However, in this scenario, we're going to look later at how this comes into play, that it seems to imply that we could preserve unused portability election of a prior spouse for a new surviving spouse, and that's not the case. So that's likely a mistake in wording, but it's better to kind of approach that with the assumption that it's going to be the difference between the basic exclusion amount and your estate tax base. And I brought this up in part 1, but I want to remind you again that this election only preserves the unused estate and gift tax exclusion. It does not preserve unused GST exemption, which requires its own type of special planning that we'll look at later. So that's it for our basic eligibility. In terms of what's next in this series, we're going to look at a big question, which kind of is a segue from our last point. What happens if the surviving spouse remarries? So that's kind of teed up in our next discussion, but what we're going to find out is if you're unlucky enough to be widowed multiple times, you can't go through those marriages accumulating multiple unused exclusion amounts. We'll also dive into a bigger question of who qualifies for the disuey and do they have to be a U.S. citizen or resident. We'll dive into the preparation of the 706. We'll compare benefits and detriments of portability versus traditional AB formula planning methods, kind of weigh more on how the QTIP election factors in, and then also balance this with basis and income tax planning implications and what benefits you might get from an income tax perspective with the portability election. As always, if you're a tax and estate planning practitioner, if you have questions or topic suggestions, you can email those to me at griffin.bridgers@gmail.com with the caveat that I cannot give tax or legal advice in response to your questions. If you like this or my other content and you'd like to have me as a speaker for any of your upcoming events, please feel free to reach out as well. But I thank you again for listening to this video, and I look forward to seeing you in my future content.